again, everyone, and welcome to another edition of the Inside Lowell Daily Pulse. I'm your host, Teddy Panos, coming here from the WellPoint Studios on this Thursday, February 26th. Excited to be joined today by a guest that, well, for the last couple of days, a lot of people have been highly anticipating this visit because it strikes at the core of the latest and greatest City of Lowell controversy, and that is the senior center ownership situation. Who owns the building? Who's screwing who and whatnot? Well, a lot of speculation, a lot of Facebook attorneys out there. Hell, there's some podcast attorneys out there as well. But I figured it's time to get some answers from a real attorney, a real estate attorney. And we have one joining us here in the WellPoint Studios this morning. Attorney Krista Emerson is joining us. Hello there, counselor. How are you?
Good, Teddy. Thank you so much for having me today.
Glad to have you here. Thank you so much for coming in. I was hoping to see if I could get another attorney to come in so we could set up a little discussion back and forth and have some opening and closing arguments and let the jury decide out there, the viewers. But I'm glad that you're here. There's a lot to talk about regarding this situation. And even as of this morning, I was continuously getting questions and documents, and I've worked them in to the questions. So let's talk about this situation and let's get some answers from a legal standpoint.
Yes.
We're going to talk to Attorney Emerson in just a quick moment. First, let me thank my Daily Pulse sponsor, Ray Booten. He's a licensed realtor in Mass and New Hampshire. He's a certified appraiser in both states as well. So if you're looking to buy or sell a home, a business, or a commercial property, you need to get in touch with Ray today. And by the way, if you need a real estate attorney, we got one here that you might want to get in touch with as well. Make sure your deed and all your affairs are in proper order. But if you want to buy or sell that property, get in touch with Ray. RealestateRayBooten.com is his web address. That's RealestateRayBooten.com. I also want to thank our friends at WellPoint for hosting us here in the WellPoint Studios. It's the only health plan offering healthcare benefits exclusively to Massachusetts GIC members at WellPoint. Your whole health is their whole point. Thank you, WellPoint. Thank you, Ray. Our other podcast sponsors are scrolling across your screen there, and we'll make sure we say thank you to them in a couple of minutes. But let's kick off our discussion here. Attorney Krista Emerson is joining us here. So first of all, we've been on a Facebook group chat since the holy war over the high school location debate. Interactive, I don't know, I pop in there every couple of weeks depending on what's going on. And I didn't realize until earlier this week that you were actually a real estate attorney.
Yes.
That is what you do. You were kind of speaking definitively on this matter, and I sensed she knows something. So let's talk. So you are a real estate attorney.
Yes.
Tell me a little bit about this. How long have you been doing this? What is the specialty? What kind of things do you deal with? So folks understand that you're not one of these Facebook or podcast warriors as I am. You actually kind of know a little bit about real estate law.
Yes. So I've been an attorney since June of 2010. I co-own Landmark Title and Legal Services. We're right over the line in Tewksbury behind 𝐂𝐴TMIAN. Our practice is heavily focused on real estate, residential and commercial closings, residential, commercial evictions, all things real estate. We create LLCs, we create trusts for real estate entities. So this is really in my wheelhouse. I've been doing this for a long time, and I don't usually pipe up into the group that often in the group chat unless it's something I know about. And I definitely was reading this and saying, "Oh, there's some issues here." So I do find this very interesting, and I think that a lot of people are misunderstanding kind of what's going on because at first glance, if you read that one line or those two lines from each document in a vacuum, you think you know what you're talking about.
It's a slam dunk. I'm looking at it and I'm like, somebody's getting screwed here. Somebody should not only sue to take possession of that property, but get some damages for getting screwed. It's
not quite that simple. And while I do agree that I think it will be very unfortunate for the city, the way that I see this shaking out, I think that there are some serious fatal errors in the way that these documents were drafted and the things that were recorded, and you can't overcome those to validate this gift. There are several issues, even just in the lease alone, that I saw that are technical errors that create major issues for anything that came down the line. So I don't know how much you want me to jump into that right now.
So we're going to look at it, and we've actually got some documents highlighted that underscore what exactly you're saying. But the fact that you're a real estate attorney, why is that matter? How does that compare to other types of law? First of all, the training that's required for it, but also the fact that, because I hear a lot about fraud and implied contracts, and if you make a promise, it's as good as a contract, which from my one semester of business law at UMass Lowell back in 1985, I'm like, yeah, if you give your word, it's an implied contract. How is real estate law different than other forms of law, and how does it pertain to this particular instance?
So real estate law is different in that there are different provisions. Everything in real estate has to be in writing under what's called the statute of frauds. The statute of frauds dictates that, first of all, any contracts that are going to be performed in less than a year, more than a year, have to be in writing. All contracts relating to real estate have to be in writing. You could say to me right now, I'm going to sell you my car for $5. I can hold you to that oral agreement because it has nothing to do with real estate. You cannot tell me you're going to sell me your house for $5 and I can enforce that. It's not in writing. Doesn't count. There's a lot of back and forth going on about, detrimental reliance and things like that. And again, if you just simply Google, you might think you know what you're talking about. One of the biggest caveats with detrimental reliance is that you are not able to claim damages if the issue could have been avoided. This issue could have been avoided in 2001. And I can really dig into, why I think that is. And, now looking at this 25 almost years later, you can't unring the bell. You can't go back and undo it. But the way that this all went down, and I moved to Lowell in 2006. I was in college in 2001, living in Tewksbury when this all happened. I don't know anybody involved in this. I knew nothing about the City of Lowell government at the time.
I wanted to ask, do you have a dog in this fight? Are you
not at all
part of one of Lowell's political warring factions? Or
not at all? Okay. I am the least political person you'll probably ever meet. I don't know any of the players in this at all. None. Obviously, I have friends who are on the city council and who have been on the school committee, but I don't know anything about who the city manager was at the time, who the city solicitor was at the time. I don't know either of the parties who are the trustees of the trust or members of the LLC. I don't know any of them. Okay. So I zero to gain by anything I say today.
Okay, but you are a real estate attorney, yes. And this is, do you practice other types of law?
I do a little bit of disability work. My background prior to going into private practice, I was in the human service industry. I worked with survivors of traumatic brain injuries and people with severe mental illness living in the community. Did a lot of disability cases, just kind of parlayed into private practice. But I'm so busy with the real estate work that it's not a huge part of my practice. It's a growing part of the practice, but it's not one of our main focus areas.
And if I could just kind of pull out an analogy, because I was having a discussion with somebody who is an attorney and was very opinionated on this. And then I said, well, are you a real estate attorney? No, but some of this stuff is basic. And I'm like, well, my wife is also a medical provider. She's a cardiac nurse practitioner. Can a podiatrist, is a podiatrist a medical provider?
No.
Yeah. Is an allergy specialist? Yeah. But if you're talking about a heart issue, you probably want to go see a cardiologist and a cardiac nurse practitioner. So if you're talking about a real estate deed issue and all this stuff, you probably want to talk to a real estate attorney at least.
I would agree. Yes. So there's so much interplay here because you have a lease, which is landlord-tenant related. You have a deed, which is obviously conveyance related, buying and selling of property. And then you also have the business associations part of it with the corporations and the trust and the LLC, which further complicates things.
Are trusts an area of real estate law expertise as well?
So we do a lot of realty trusts for our clients. It's just a different way of holding title.
Because you're trying to protect the home with elderly and nursing homes and clawbacks and stuff. So.
And the whole goal of a trust is anonymity. The trustees don't necessarily own the trust. The trust owns the property. The trustees are the managers of the trust. But the trustees essentially work in the interest of the beneficiaries. most of the time you have no idea who the beneficiaries are unless you're told. Sometimes you're told who one beneficiary is. Sometimes you're told who all the beneficiaries are. There could be that the trustees are their own beneficiaries. It could be that there are 100 beneficiaries. It could be that an LLC is a beneficiary, which I believe is the case here, but it could be that there are 15 other beneficiaries on top of it. And as a trustee, you have what's called a fiduciary duty as a trustee to your beneficiaries to not waste property, to make sure you maximize the profits of the trust property, like this 276 Broadway property.
Yeah, and all this stuff is relevant, as we saw Tuesday night on the city council floor. But again, to kind of liken it to something, it's, if the children of an elderly person are trying to protect themselves in case of debilitating injury and needing to go into long-term care, you protect the property. Somebody who wins the lottery doesn't want the world to know that they just hit the $500 million megabuck prize, so they set up a trust and then stay anonymous. So this is common, and you deal with this stuff all the time.
Absolutely.
All right. We're chatting with attorney Krista Emerson. She's joining us today on the Daily Pulse, the show that keeps its finger on the pulse of Lowell and the world around it. Today, a lot of focus on Lowell, a lot of focus on the senior center, but it does kind of relate to the legal world around it. We're going to get into the meat of the conversation here and highlight for you, show you some of what she's talking about here within the documents that have been so widely circulated. First, let me thank all of my podcast sponsors here at Inside Lowell. My Daily Pulse sponsor, Ray Booten, licensed realtor in Mass and New Hampshire. Find him online at realestaterayBooten.com. Thanks as well to WellPoint at WellPoint. Your whole health is their whole point. Washington Savings Bank, banking that goes the extra mile. Make the switch now to Washington Savings Bank. TMI Properties, TMI Cares, managing and developing their own properties for over 30 years. Experience the quality, the value, and the care of making TMI the choice for your home. Mahoney Oil, providing warmth and protection to generations of families throughout Greater Lowell and Southern New Hampshire since 1925, and by the Greater Lowell Community Foundation, improving the quality of life in our communities through strategic, impactful philanthropy. Back with our special guest here on this Thursday, February 26th, real estate attorney, Krista Emerson. All right, so you've been watching this. Now you're following it. We've been chatting since Tuesday online, on the phone, trying to get an understanding of what's going on here. What's your take on this whole situation? What happened here? Who screwed up, and ultimately who's holding the hammer in this legal dispute?
Well, it's really unfortunate, but my analysis of this, based on all the factors and looking at all the documents, is the city is out of luck. There are too many inconsistencies here and too many issues that show the intent to actually gift the property to the city from the trust. There's nothing that I see that shows that the trust has agreed to gift this property, and the trust is the owner of the property. There's a deed recorded from October 19th of 2001 that the city deeded to City Barns Trust. I believe it was Nicholas C. Saris and George Barakis as trustees of the City Barns Trust. The problem comes because the lease was between City Barns LLC and the City of Lowell. The gift clause in the vote involved Lowell Restoration Inc. Now, they may all have similar players, but they're three separate and distinct entities. That's like you, me, and the fence post, going out and there's a fight and I get in trouble. You and the fence post can't get sued for anything that I did. We're three separate people. The point of the corporate structure is to give yourself your own separate identity. So as we were talking about earlier, you can always represent yourself in court unless you're a business entity, a trust, a corporation, an LLC. You cannot represent yourself because you're a separate and distinct individual. So there is a lot of chatter about, they're all owned by the same people. But they're three separate and distinct entities. It doesn't matter how similar their names are. There are layers and layers and layers.
Because that was asked the other night, is City Barns LLC and City Barns Trust, is it the same beneficiaries? And the attorney representing the individual, Attorney George Theodorou, said, yes, they're the beneficiary. Does that, does that cut and dry it, or is it?
No, I don't think it does, because the LLC is managed by Lowell Restoration Inc., who has different corporate managers, and they have a duty to their shareholders. We don't know who their shareholders are. There could be 100 shareholders. So it's not as simple as saying, well, they're the same people, so the intent was the same. Not necessarily, because these layers were done for protection, asset protection. But that's why it complicates things. So the LLC manages the trust, but the LLC is managed by a corporation who also has other individuals involved. And 3 of those corporate directors are not the trustees named in the deed. And again, we don't know who the shareholders are. We don't have a list of the shareholders. It could be 100 different shareholders.
So who's technically the owner? Is it the beneficiaries of one of those 3 entities?
So the trust is the owner, but in a trust, the people who really own the rights to the trust are the beneficiaries. The trustees manage for the benefit of the beneficiaries. So they could be one and the same. You could have a trust set up for your kids. You're the trustee. They're the beneficiaries. If you say, hey, I'm going to buy all this real estate, but then I'm going to gift it, and your kids get older and they say, hey, Dad, we had this millions and millions and millions of dollars of real estate, and you gifted it to somebody, you had a duty to us as the beneficiaries. Not that I think they would, but they could sue you for that, for breaching your fiduciary duty. It's just far more complicated than looking at these little pieces in a vacuum and assuming that everything is fine because they're all the same people. It's not. You know, you got 3 different parties named in these documents, 2 of which are recorded. I think there's issues with the lease in general, but if you look at the deed and you see that it's deeded to City Barnes Trust on October 19th of 2001. That is who the city drafted the deed to. The city drafts the deed as the seller. The city, if the city did not draft the deed, I would be very surprised if the city did not draft their own deed to City Barnes Trust. The city drafts the deed. Buyer gets to make revisions. If those revisions are not in line with what the city wants, they go back and forth. They make sure that everything is done the right way. There's no reference to City Barnes LLC in the deed, who is the lessor on the lease. The lessor is the landlord. So you have 2 separate entities right there. But then contained in that lease and contained in the vote are promises that another entity is going to do something. This is where the issue is. I can't promise somebody to sell your house for $5 because I don't own your house. It's what we call in law school the Brooklyn Bridge rule. You can't sell what you don't own. And just because they're the same parties in the LLC and the trust doesn't mean you can sell the property of one through the other.
Did I hear you reference that there are, in one of those 3 entities, there are other beneficiaries?
Yes. There's corporate officers.
So they're corporate officers.
They're corporate officers.
So that in and of itself makes one of those entities different than the others.
Yes.
Okay. Let's kind of take a peek at some of these documents, because I get lost myself as I was trying to follow these conversations. I was dizzy. I saw the line that said we'll gift it back after 20 years. Everybody saw that line. That was the cut and dried line. And if you do not follow that promise, that legal promise that you signed for, you then fall under the statute of frauds or some kind of thing. You're saying the statute of frauds does not apply here the same way. Why?
Well, the statute of frauds certainly applies. It applies to all real estate deals and all agreements not to be performed in a year. That's a given. That's a basic legal concept. The statute of frauds is not necessarily something that even really relates so much to this, because everything is already in writing. The intent is in writing, but the problem is within the writings. Okay. There are defects in the writings that cause the major problem for the city in getting this gift back.
All right, let's try. I like to do show and tell because it helps me. I'm pictures help me a lot. But so what we're looking here is the quit claim deed. Are there any other kind of deeds, or are they all?
Massachusetts only uses quitclaim deeds. There's quitclaim deeds, warranty deeds, special warranty deeds. Massachusetts, because we like to be different, our quitclaim deed is the equivalent to essentially any other state's warranty deed.
Okay.
So this says that title is clear, The party conveying has full right and authority to do that. There are no liens or encumbrances that are not disclosed. Title is good, clear, and that they're buying a property without any defects in the chain of title. Can't talk about structural defects, obviously, but any defects in the chain of title. So you'll see that the City of Lowell deeded in the top, and then you see that highlighted part, Nicholas C. Saracen, I don't have my glasses on, and
Nicholas
George
C. Saracen, George D. Bechrakis as trustees of City Barnes Trust.
Under declaration of trust.
So on the deed, up until the dispute starts in 2021, there's no dispute that City Barnes Trust owns the property.
Correct. And there is no deed out after this to City Barnes LLC, Lowell Restoration Inc. City Barnes Trust is the current owner of this property.
Okay. And this becomes problematic because we don't see City Barnes Trust in other documents where we should. Correct.
Yes.
All right. So we'll go from that to let's kind of look at what the City Council voted for.
Yeah.
Back in 2001, May 8th, 2001.
Yep.
Unanimous, 9 yeas. Richard C. Johnson, the city clerk. John Cox, the city manager. By the way, just a moment of correction here. Yesterday, I was thinking Christine O'Connor was the city solicitor because she was the city solicitor for a long time. I said I wasn't sure, but I said her name. I was wrong. It was not Christine O'Connor. She hadn't come in yet. The city solicitor in May of 2001, when this thing happened, was still Tom Sweeney, the guy that looked like Phil Donahue, if you remember the daytime TV show. But I stand corrected. Christine O'Connor was not the solicitor. It was Tom Sweeney at the time. I apologize for speculating wrongly. If you speculate rightly, I guess that's not a bad thing. Anyway, all right. We highlighted an area here that you say is the first warning flag.
Yeah. So this is the vote. And what it says there is that Lowell Restoration Inc. is going to gift back the property. Now, Lowell Restoration Inc. is the lowest layer of that trust.
The one least able to sell you the Brooklyn Bridge.
Yes, because Lowell Restoration Inc. does not own and never owns the property. They never own the property. So Lowell Restoration Inc. as the corporate entity that is managed by City Barnes LLC, that is the beneficiary of City Barnes Trust, is the lowest rung on the ladder. They have no authority to do anything. None. They don't own it. They can't promise to gift it back because they don't own it. Now, earlier in the vote, and I don't think we have that pulled up, it says Lowell Restoration Inc. or its nominee. If this line here had said Lowell Restoration Inc. or its nominee, which could be City Barnes Trust, not so big of an issue.
Okay.
It doesn't. That is a big problem. Because you're saying right now, in this document, the only party that is bound to gift back is Lowell Restoration Inc. If at any time City Barnes Trust deeded to Lowell Restoration Inc., probably can hang your hat on that. But they never owned it.
This document was clearly recorded by the City of Lowell, by the city clerk or whoever writes this stuff out, the law department.
Yep.
And then the signatures are attached.
Yep.
You can see it. That's and then the Richard Johnson, the clerk, signs it, attests to it. Richard Howe Jr. is the Register of Deeds, so we know he's accepted all this. So if on the first document, and I'm going to cover that one up for a second here. If on the first document you're giving it, you're selling it to, granting it to. Granting to means the same as selling it to.
Yep, selling, granting, conveying.
So you're granting to City Barnes Trust, then why on earth are you having Lowell Restoration Incorporated sell it back or gift it back as opposed to City Barnes Trust?
That's a good question.
City Clerk, Rick Johnson, probably he's seeing all these documents, makes a mistake. I get it. City Solicitor should have caught this?
100%. This is basic stuff. If somebody says, hey, I want you to deed to us, and you're looking at this vote that you did in May, and it says, well, if we want the gift back, it's got to go to Lowell Restoration Inc. It doesn't. It goes to City Barnes Trust. That's a big problem. I see that as a big problem.
Somebody said to me, a first-year law student, would have picked up on this. Well, do you have to be into business law classes to realize, or in any business contract you sign, if your entities do not match,
you can't bind
you've made the contract null and void, even with intent?
Parties have to have the capacity to enter into the contract. If this was Cyrus or Baracus individually entering into this contract, who are also managers, again, different story. It's not. It's one entity entering into a contract that's attempting to bind another. Can't do that.
Right.
Can't bind something to somebody. You can't be bound to sell or gift something to somebody that you don't own. Okay. And Lowell Restoration Inc. never owned the property.
Right. And I'm not an attorney. Yep. I just play one on podcasts, but I have heard the saying, I've got a bridge to sell you. That came from I can't sell it to you, but if you're dumb enough to give me money for it. So clearly people who were involved in this transaction should have also been aware of this. If it's sloppy on the part of a clerk or whatever, I get it. But at some point, lawyers review these.
Absolutely.
So we're either somebody didn't catch it, or somebody intentionally created this scenario.
I can't speak to that. I didn't even live in the city of Lowell in 2001. I was in college.
Lucky you.
I moved here in 2006. I can't speak to what the political landscape was back then, if that was even a possibility. But I mean, looking at it as a professional, that's very, very sloppy work. And then if you look at the lease, this is where it gets even sloppier.
Okay, and let's do that. Let's do away with our city council vote. And here is the actual lease. And you had me highlight this indenture of lease made on this 5th day of October 2001 and between City Barns LLC.
Yes.
So we've seen a document with City Barns Trust. Mm-hmm. We've seen a document with Lowell Restoration, and now we're seeing a lease agreement with City Barns LLC,
who also never owned the property. So I question whether this lease was ever actually valid. City Barns LLC, we know, never owned the property. City Barns Trust owned the property. Now, if you recall, the date of the conveyance on the deed was October 19th of 2001. This lease is dated 2 weeks prior by an entity who never takes title.
All right, so let me just go back to the deed. And
you may not be able to, I don't.
So a declaration dated October 5th, 2001.
That's the declaration of trust date. So that's the date that they signed and created the trust and recorded it. But that was actually recorded on October 19th of 2001.
So if you look further down that document, you will see it. I don't think
actually, it would be on the top right for the recording, but it's cut off a little bit.
Okay.
So October 19th of 2001 is the conveyance date.
Okay. And by the way, that is kind of verified. Let me call up this next document that shows when it was faxed.
Yes, these exhibits were faxed on October 19th.
An exhibit was faxed on October 19th. Okay.
So let's go back to the first page of the lease.
Okay.
So remember we were talking about the Brooklyn Bridge rule. You can't sell what you can't own. You also can't lease what you don't own. Now, the owner and the lessor don't have to be the same person. It's common that people own property and have a management company who manage it. And the management company can enter into their leases with the tenants on behalf of their principal, who's the owner. While the trust and the LLC may have been created at the time this lease was entered into, the owner never owned the property at that time. City Barns Trust did not own the property at this time. I think this is a big problem because you can't lease a property that you don't own. If the deed went into City Barns LLC, you could argue that it was ratified because they then became the owner of the property, but they never take title to the property. City Barns Trust. It doesn't matter if they have two words the same and their suffix is different. They're two separate and distinct entities. The trust owns the property. The LLC doesn't, even though it is a beneficiary. The trust is the owner of the property, managed by the trustees.
So if somebody from the city had caught this, they technically could have stiffed City Barns LLC and not paid them a penny of rent.
Quite possibly. Yes, they wouldn't have been bound to the terms of this lease, but there is in the court system that you don't get to live or occupy a property for free, you're still required to pay the fair market value of it. So they would have still been required to pay. Now, I don't know the municipal laws as to whether or not a valid contract needs to exist. I believe it does in order for rent to be paid. But this is something that should have been caught long ago. If you're drafting a lease, you need to know who the owner is. And the city would have had an opportunity to review that document. My guess is they had multiple people in the law department reviewing the document and also reviewing the deed that they drafted. Like you said, a first-year law student would have caught that the LLC and the trust are two different entities. If it had said City Barnes LLC, managing agent for City Barnes Trust, again, still a problem because they didn't own the property, but not as big of a problem as I think we have here.
Okay.
So you have a predated lease before ownership was ever taken of the property. So I question whether this lease is valid at all. But then if you go to the exhibits, back to the exhibits, and you didn't copy all the exhibits, which is fine. That is faxed 2 weeks later. After the conveyance, or right around the same time as the conveyance to City Barnes Trust.
And by the way, it's Exhibit B, which once again says this will be given back to the city in 20 years. But if you've got an Exhibit A dated on October 19th, then your Exhibit B is October 19th or later.
All of the exhibits, for anybody who's looked at the lease, all of the exhibits were faxed at the same time.
Okay.
Here's my issue with the exhibits. Looking at the lease in general, it does say, and again, this is a technical thing. Is it undeniably fatal? No. This part I don't think is. It says see Exhibit A, see Exhibit B, all the way through. I think there's Exhibit F or H attached here too. The problem is it's not attached here too on October 5th. We get these exhibits that are faxed on October 19th. The biggest issue I see with those exhibits, there's no initials on them acknowledging that the lessor and the lessee agree to them, and there's no signatures. So that begs the question, are these the exhibits that were intended to be attached to the lease? We don't know. That line in Exhibit B, is that something that was negotiated? We don't know. It's not initialed. All addendums in real estate contracts should at least be initialed and absolutely agreed to by everybody. Undeniably, they're not.
But it appears we know because that line was on a couple of different documents. So the intent was clear.
Yes.
But you're saying, again, with real estate law, you got to be a little more careful in dotting I's and crossing T's. Is that correct?
Absolutely. And it's so simple to just say, I need your initial on this. I need your initials on this document. Not the strongest issue as to why, but like I said, it does beg the question and get your wheels turning as to, are these the actual exhibits? Is this what was negotiated? Is all this verbiage what was negotiated? We don't know because nobody has verified by way of initials or signatures that those are true copies of the documents that should have been affixed to the lease. Obviously, if the lease is invalid on its face because it was entered into weeks before they owned the property, then that provision doesn't stand anyway. The lease is invalid on the whole. And that postdates the vote, which says Lowell Restoration Inc. And it is predating the conveyance. There's so many issues here. And as a first-year law student would have caught that there are three different players here. If you've gone through contract law, which is your first or second semester of law school, you're looking at this and saying, you can't bind this party because they're not the party to the contract. This is not the party to the contract. You could have put in Lowell Restoration Inc., its nominee, or its assigns. It's not in there. It's basic information and basic verbiage that's missed that literally is going to cost the city this property. If this was caught in 2002, 2003, 2004, anytime during the term of the lease, could they have done an addendum that says the lessee is the City of Lowell, the lessor is City Barnes Trust? Yes, and we wouldn't have this problem. They would have said they ratify all the terms of the lease. They didn't do that. They didn't say anything now until 2025, 2026. They enter into the new lease in January of 2026. This is a big problem. This is a real big problem. And, everybody talks about, they could make good on their promise. They could make good on their promise. We weren't there, to know what happened. Like, yeah, we see these lines in a vacuum, but if the city really wanted to make sure they were getting this property gifted back, they really should have dotted their I's and crossed their T's and made sure that it was a sure thing.
Right. And that's an important point, because I've reached out to Attorney Theodoros. I've reached out to the owner, Mr. Saris, through other folks to say, hey, if he would like to get his side, because he's getting his, you know what's kicked in publicly. And if this were me and my reputation were being, I think thankfully we've ended the George Bakrakis, bashing, because he's no longer on any of this stuff. And the George Bakrakis I know wouldn't do something like this. I won't speak for Mr. Saris, yay or nay on that, but we've reached out and given them an opportunity. But if it were me getting my public reputation bashed like this, and I had something that was like, yeah, but wait a minute, you don't know X, Y, Z, I'd be screaming from the rooftops about it. So you're saying that we still don't know the full thing. Is it possible that everybody did these things, a bad mistake was made, and everybody, was gonna honor the lease, the thing, but then somewhere along the way the relationship went bad? Maybe another negotiation, because they are involved in other properties. A negotiation went bad somewhere. Maybe a promise made, or they were fighting over repairs and maintenance, which I know has happened. And suddenly the owner says, I don't care what I promised you. I'm not doing this, and I know there's a loophole here, and you can't hold me to this.
And that is absolutely possible. Absolutely possible. The problem is that bad mistake is why they could do that. But even the oral promise afterwards is not enough, because the statute of frauds requires that everything in real estate be in writing. Anything that's going to not be performed within a year has to be in writing. So you can't rely on the oral promise. The subsequent agreement has to be in writing. You rely on the four corners of the contracts.
And it has to be in writing where? On the lease, the deed?
Any kind of writing. You can write it on a napkin. I promise to gift you this property. Signed, trustee of the City Barns Trust.
But, which it appears we do have some signatures like that, but you're saying, again, the thing that allows the loophole is you don't have the right entities on the right documents.
Right. You don't have the right people promising it on the documents. Okay. There are issues within the documents that are easily caught and easily avoided. And that's where that whole, I've seen the detrimental reliance argument. They could have been avoided. Somebody doing their job, it could have been avoided. The city is really, and I hate to throw the city under the bus, but the city is really the reason we're in this situation to start with, because they didn't do their job and execute their duties correctly in making sure that all of these documents lined up. What they should have said was, okay, we have this vote. Lowell Restoration Inc. is going to gift us the property. This has to be the lessor. This has to be the party on the deed. If they had said City Barns Trust as nominee for Lowell Restoration Inc., that's fine. Nominees are fine. But there's no notations there, and we have nothing aside of this. Now, there's also a purchase and sale agreement between the parties that I've not seen. I don't know what the purchase and sale says from the city to City Barns Trust. I don't even know who the person is who's on the purchase and sale agreement, which could further complicate things.
All right.
So, nobody's seen that. I don't think we're ever going to get that. But this is a classic case of the ball was dropped, and now everybody's scrambling to try and fix it, and I don't think it's fixable.
All right. And again, I want to ask a bunch of questions, and I will ask a bunch of questions that were sent to me by people, and they're telling me that attorneys have advised this. Again, please put those attorneys in contact with me, and who are giving different answers than what Attorney Emerson is giving, and I'm happy to have that attorney on and explain. I'd love to have the two of you on together and battle it back and forth and have the jury, but I will ask these questions that are given to me by non-attorneys. Okay. It's the responsibility of the title purchaser to have inspections and make sure the title is clear. I think I answered that one myself by saying, the title was clear in 2001. The issue is, what does the title say today?
Yep. So the title says the same thing it said in 2001, is that City Barns Trust is the purchaser. So the buyer always has an obligation to do a title examination, make sure there are no liens, encumbrances, anything that affects the ownership of the property or impairs the value of the ownership. That's not an issue. That's not an issue at all. There have been no deeds out from City Barnes Trust to any other entity. That is the current and original owner of 276 Broadway, City Barnes Trust.
Okay. Who filled out this deed and this paperwork? Does that matter? Is it possible that the city said, you know what, we're real busy? I don't know what they were dealing with in 2001. Maybe they were preparing the human dog sled races for Winterfest at that point. And we'll trust, City Barnes and whoever this entity is to have their attorney write up this document, and we'll sign afterwards and we'll file it with the Registry of Deeds.
Well, it's possible, but it's also on the city to verify that what they're conveying is what they have contracted to convey and all of the information is correct because they sign it.
So if they were duped intentionally or accidentally, they still need to do due diligence.
Absolutely. We get deeds all the time that have issues in it. They have parcels that are wrong. They have book and page references that are wrong. When you have corporate entities and they don't put the limiting language in for the corporate grantee, corporate grantor, you could essentially be selling me all of the property that the LLC owns in the Commonwealth of Massachusetts. If you don't limit that and you don't do your due diligence, even if somebody else prepares the deed, you're signing it. Sure. You are authorizing the conveyance in your professional capacity.
Have the real estate laws changed since 2001? Were there different laws in 2001 when this was signed? Okay. No. Do we know if the City of Lowell has somewhere in that solicitor's office, I believe Solicitor Williams had like a labor background, but do we know if a city or town has a real estate attorney specifically in their solicitor's office or on retainer, or if they don't, would they be very wise to get a specific real estate attorney on there because cities and towns own a lot of property? I
am not certain if they do. I do know that there used to be an attorney in the law department who was a real estate attorney who has recently left within the last year. I don't know that he was specifically there for real estate related purposes. But
would that be Attorney McKenna?
Yes.
Who at one point, I believe, was the acting solicitor at some point in between Solicitor Tomlinson and Solicitor Williams.
John and I actually just recently did a deal together.
He knows his real estate stuff.
He does, yes.
And we know that it's going as far back as 2022. Somebody flagged this and said, there's a problem. Attorney McKenna was... I believe on the solicitor staff in 2022?
I think so.
Okay.
I think so.
Right.
But at the same point in time, if this is, like I said, you can't unring the bell. Right. So you can't go back and redraft and amend things. Now, at that point, the lease had already expired. It wasn't even in the current lease term, so you can't even amend it because it's over. It didn't automatically renew. After those 20 years, the lease was over. But it's definitely, when the city owns all the real estate, you got to have an attorney who has some real estate experience guiding you on these things. And, the city was a tenant and there are other obligations that come with that. And again, I hope it doesn't get to litigation where anybody sues anybody, but, the market rent of that unit right now is insane based on per square footage value and the number of square feet. You
spoke to me about that yesterday when we spoke on the phone. You said something else you found peculiar was that the rent
never escalated.
The rent was the same in year one as it was in year 20. It never went up.
Yeah.
Why is that unusual, and what could that indicate about why we're where we're at today?
I don't think it really necessarily indicates anything. I do know that the city financed a portion of it, so that could have been part of the agreement that says, well, we're not going to have a rent escalation clause because you're financing and paying us as the bank, essentially, for part of the transaction. But in commercial real estate, usually every 3 to 5 years there's an escalation in the rent. Sometimes it's every year. Usually after a certain period of time, there's, 1.5% or 2% increase because taxes go up, insurance go up, utilities go up, common area maintenance goes up. And that never happened here. So for what they were paying, which I believe was just over like $57,000 a month in rent, is probably upwards of about $250,000 a month now for 2,100 square feet. If you go at the $12-ish a square foot for office space, which I think that the senior center would be deemed more office space than any kind of industrial or flex space.
Which was brought up as people were trying to talk about what the rental per square foot is, and we were told that public use buildings are a different animal, and I don't know what that number is, but it makes sense that it would be higher than than an office building where I am right now.
Even if it was at $5 a square foot, you're still looking at over $100,000 a month.
Okay. Which brings us to one thing we discovered in the notes that were, or the executive session minutes that were released. Have you had a chance to see those executive session minutes? Okay. The attorney for the person who says he's the owner and you believe is the owner is not only threatened, as we were told this through social media and counsel speaking, that they threatened to kick the senior center out of there, aka kick the seniors out of there. Yeah. We saw that the attorney has asked for treble damages as well. I'm assuming that is back rent. We know rent hasn't been. So the lease expired at some point 2021. There was an agreement made to do a 1-year extension. Is that because somebody said, oh, shoot, we got a legal problem here or not? We don't know.
Probably not. They were probably trying to renegotiate terms. They did an extension on the same terms while they were working on it. That's my guess. But the treble damages claim, I don't think flies. There are 2 separate statutes under Mass General Laws, Chapter 93A, which is the consumer protection statute. As a consumer, you are entitled to double or triple damages plus attorney's fees and costs if you can show an unfair or deceptive practice occurred, and they don't reasonably offer to settle. And in business to business, you're capped at double damages. Okay. I would argue the City of Lowell is very much a business and not an individual, so I don't think you can get triple damages. Okay.
You actually gave me a little hope there. You're entitled to double or treble damages if you've been deceived. In this case, it's alleged that the person doing the deceiving is the one also seeking the damages. So you believe, worst case scenario, we go to court, we lose, we have to pay 4 years of back rent or whatever. It's whatever that number is, not double or treble damages?
Yeah, I don't think so. I think it's only going to be single damages based on but it'd likely be the fair market rent. So it's not necessarily going to be the $57,000. It really depends on the judge and what argument you make and what experts you bring in. You know, you have a commercial real estate expert who says, I've rented a spot of this size and it was $130,000 a month. I've rented a spot that's slightly smaller, and I rented that for $120,000 a month. You're still looking at double what they were paying. So even if you're not asking for double damages, it's quite possible for that period of time you're getting double what you were expecting anyway.
All right. Who owns the building today? And you're, as a real estate attorney, who is the owner of the building today and will be until he or she decides to sign a transaction at some point?
City Barnes Trust, same as it was in October 2001.
If the City of Lowell were your client, if for some reason the city council wants to hire an outside independent attorney, by the way, I think you just cost yourself the opportunity. I think the 5 who want to go to court and fight this, I don't think they're going to call you as their attorney after this discussion. But let's say they do. Yeah. Let's say they're impressed with your knowledge and say, hey, can we talk to you? Here's our points. This is what we think. Based on what you know today, how would you advise your client if the City of Lowell were to reach out to you?
Just accept that issue was made 25 years ago. You cannot correct it now. There are too many errors. One error potentially is forgivable, Scrivener's error. There are way too many issues with this.
Will they find a real estate attorney to take this case? You're gonna, because the saying is, you show me 2 attorneys and I'll give you 3 opinions. Show me a city of 100,000 attorneys and I'll give you 300,000 opinions.
I'm gonna say this as professionally as possible. Even if there is no case, there is going to be an attorney who will take it for the fees, because this would be a very costly case regardless of the outcome. I personally am of the belief that if I don't think you have a case, I'm not going to take it. I'm not going to make somebody, give somebody false hope and say, yeah, you got a shot. You get a 50% shot. I don't think there's a 50% shot. I think there's no chance.
All right. So that's going to court.
Yeah.
Some folks are saying, look, can we just hire another set of eyes to look at it? Independent, not the city solicitor, who apparently is not independent, not KP Law, which is on retainer, and whatnot. I think there are other attorneys that the city kind of has on retainers. Hopefully one of them is a real estate attorney, but not them. We, whoever, and good luck to the council, getting a majority of votes on hiring which attorney. But let's say they hire an attorney just to look at this and tell them either, yeah, you got a case, or agree with the solicitor and say what you're saying, don't bother, you're going to lose. What would that cost? What would you, 10,000, 20,000, 100,000?
depends on the attorney you hire and their hourly rate. I would say this would be no less than 15 to 20 at a minimum.
And a $500 million budget, that's, that's...
I mean, you got lots of documents to work through. You're going to have to talk to people who are involved. You know, if this is something, it's going to get really, really pricey. It's going to get really pricey. You know, I don't see anything like this being like, you know, oh, we can pay somebody $1,500 and they'll figure it out. There's just too much. I mean, you'd have to actually have a conversation with every person who was involved, find out who drafted the deed. Hey, what do you remember about this? You know, not necessarily depose them, but at least having conversations with them, tracking them down, finding them.
See, I want to see the court fight just for that alone. I always like to unearth the skeletons, you know?
There's so many people involved, you know, and it depends on the scope of it. Do they want to talk to everybody who is in the law department? Do they want to talk to everybody who had hands or eyes on this document? Do they only want to talk to the city solicitor and the assistant city solicitor? Do they only want to talk to the city manager? It really depends. But I mean, looking at the document, specifically what has been recorded, the parties don't line up. And again, simple fixes like saying, oh, we should put in there Lowell Restoration Inc. or its nominees or assigns. I think you got no problem. Lowell Restoration Inc. could have assigned and they nominated City Barns Trust to take title. Doesn't say that. It says Lowell Restoration Inc. is going to gift the property back in the vote. And then it says in the lease, City Barns LLC is going to gift the property back. Neither of them own the property. It's just too attenuated to see any way where City Barns loses.
All right. Let's say that this was just a horrible mistake. Attorneys dropped the ball. There was no shenanigans behind the scenes. Can the city go back and recuperate anything from the lawyers working for a city are indemnified, right?
Well,
I assume.
Yeah, and you're also well out of the statute for any malpractice claims.
But if this were a private attorney and this was caught within the statute of limitations, would that attorney?
Yes.
This is because I've been in a case where an attorney said I didn't listen to an attorney's advice, and the attorney wanted to make sure I couldn't come back and sue them afterwards because they realized what was happening was so wrong that. But I had to sign a document saying I'm
you're advised of your rights.
I'm telling you to do this. Okay.
Yeah.
All right. So this is horrific legal malpractice at best, or perhaps city complicity at worst. I don't know. I mean, I don't know which one is worse.
I know. I mean, the fact that a whole department missed these glaring issues, and these are not hidden issues. Like, even if everything said City Barns Trust versus City Barns LLC, could it be a Scrivener's error? Maybe, but it doesn't. It could have just been, oh, we named the wrong party. We meant to say trust, but we said LLC. But they didn't, because they have Lowell Restoration Inc. in there too, which is a completely different name. So it's pretty bad. It's very sloppy work. It's basic drafting of contracts that was botched. And the city is going to literally be the one to pay the price for it because they're not getting this property for free.
All right. So the option is to try to sue, and you think it's a futile attempt.
I do.
The other option is to accept the lease that was put there, or try to negotiate better terms. I've heard that. Well, we should at least negotiate better terms. If you were sitting in Mr. Saris's place or Attorney Theodorus's place, and the city was threatening a lawsuit just to try to get better negotiating terms from you, would you be moved?
There's always room for negotiation. I mean, it's a lease.
To avoid going to court.
Right, absolutely.
How long of a case would this be, by the way?
That's a good question, because this would end up in Superior Court, so who knows? Years long, probably.
So this wouldn't be figured out?
This would not be figured out in any short period of time.
Could City Barns Trust, which is the owner, that's the legal owner. So City Barns Trust, could they kick the senior center out?
If they don't have a valid lease right now, yeah. I mean, they have no right to be there.
City would seek an injunction. Clearly, that was indicated in the minutes. Would that, given the fact that it's a senior center, and even those heartless judges that are turning on State Auditor 𝐂𝐸𝐬𝐬 will not turn on the seniors of the City of Lowell?
I'm not so sure about that, because the city's not paying rent.
Could they order the city to pay rent until this is adjudicated?
They absolutely could. And that would be the first thing that I would do if I represented any landlord and somebody's not paying and I know it's going to be a years long or even months long battle. I want the tenant to pay use and occupancy for the time that they use the space.
But the court would then, but there's a dispute about who owns it. So wouldn't the court have to at least initially determine who owns the space?
That's very simple to do with the deed.
Okay.
Very simple to do with the deed. You provide the deed, you provide a title.
I'm trying to find an avenue where the city could find a loophole to get out of this.
You get a professionally done title exam. You get one of the land court examiners that the Commonwealth hires and say, I want you to do a title exam, not necessarily through land court, but you have one of those land court approved examiners. They do a title exam for, $600, and it shows in the last 26 years, only City Barnes LLC has ever owned this property. That's all you got to show. That's the owner.
All right. So then let me ask the final question. As the city council determines whether to sign another lease and take another whack like Kevin Bacon did in Animal House, and then hope in 15 years they own it. This person has potentially already shown you, this property owner has shown you that, well, they've been unscrupulous before. They found a loophole and they're going back on their word. Can you write a contract? Can you write a lease that will avoid this in 15 years?
Absolutely.
It'd be a slam dunk win in court.
Absolutely. You just need to make sure all the parties are correct. You need to make sure everything is properly incorporated. Everybody is properly identified. It's very easy to do.
It's done all the time in your line of work.
All the time.
Have you seen this lease? Does this lease do that? Have you been able to see the new proposed lease?
I glanced at it, but I have not dug into it. I've really been focused on the old one and trying to determine the legality of the.
Again, if the council wants to hire you,
and like I said, there's ways around it. Like in residential, I work with a lot of property management companies who provide leases to their tenants, and I always have them put, if I have a say in it before it gets signed, ABC Management as managing agent for John Smith, who owns the property. That way, that managing agent has the authority to enter into that lease. Is it an extra step? It's a couple extra words. It's a couple extra keystrokes. But there's no doubt who that person is. Very easily avoided with a little bit of oversight and paying attention to the documents and making sure that all of the documents lined up the way that they should have.
How common is this scenario? Not necessarily a city being gifted something back in 20 years and screwing up the paperwork, but I know that there are firms out there. I own a house. I want to rent it. The folks have moved to Florida, whatever, and but I don't want to deal with the headaches of a tenant and collecting rent and maintaining the property. So I hire a company that manages this property for me. That company can't sell my property.
Correct.
But they can sign lease agreements for me, right?
Yes, because they have been specifically retained by you to do that.
But they have to point that out, that they are doing it on my behalf and that I am the owner in those.
Yes. And I don't think we have that here in the lease. There's no clarity in that lease that City Barnes LLC was acting on behalf of the trust. So I think, it's not even so much the fact of the lessor, because managing agent can always lease the property, right? The issue that I have with the lease is that it was predated before ownership even occurred, and they never had express authority, or even really implied authority in my eyes to enter into that lease before ownership was taken by City Barnes Trust.
All right. But what we're saying in essence is there really isn't a dispute over who owns it and who the beneficiary is. There may be some beneficiaries we don't know.
Correct.
Is it possible that those beneficiaries went to the people at the top who did the signing and said, I don't care what the contract says. No, we got screwed in this deal. You're not giving it back unless you get this price. Is that possible?
Absolutely possible. Absolutely possible. Because the beneficiaries are the ones who get the financial benefit of the property. So yeah, they may be getting a portion of the trust income right now, which is nothing because there's no rent being paid, but they could have benefited from the rent for the 20-year period. But the trustee, because there's only one now, the trustee still has that fiduciary duty to the beneficiaries for the entire time that they're the trustee, to manage that property, to maximize the trust income, and to not give away valuable assets. If this is a 15 by 10 strip of land that somebody wants to park a car on, nobody cares. But we're talking about a building that's worth millions and millions of dollars. This is not something that I think any beneficiary would overlook. Back in 2001, did anybody think this building would be worth what it's worth today? Highly unlikely. But it's definitely possible the beneficiaries said, you give this property away, we will sue you because A, B, C, and D are wrong.
Even though you agreed that you would do it.
Mm-hmm. Yep. So, there's a whole, morality issue. I'm not speaking to what's morally right. I'm speaking to what's legally right. I don't care if somebody has millions of dollars or somebody has $10. I'm speaking to the legality of the contracts in my eyes. I'm not speaking to anybody's character or anybody's morals because that doesn't matter to me in this case. What matters to me is the black and white in the contracts, the defects in the documents, and the enforceability or lack of enforceability that I see.
So even though the intent seems clear, the public relations, the media stories, everything was clear about what was going to happen in 2021 or at some agreed upon time, if the one party discovers a loophole that gives them an out, even if we know their intent and can clearly say they've made statements on records and signed even documents that show their intent, if they discover a loophole, that loophole supersedes everything in a court of law.
Absolutely. Absolutely. Because what's within the four corners of that document is what controls. And in those documents, none of the names match up.
Is that the case in other forms of law? Because people have sent me examples of cases and superior courts and state supreme courts making rulings based on fraud and whatever. And my question has always been, was that a real estate ruling that they made or was it something else?
Well, the tenets of the law are all the same across the board, no matter what area you practice in. But I would argue that this is not fraud because the intention, I don't believe that there was any intent to deceive. And the reason I think it's hard to prove that there was intent by the trustees to deceive is because the city drafted and had an opportunity to review these documents. Deception would be, hey, we agreed to sell this property to you, but during the term of the lease, we sold it to somebody else and we didn't tell you. So now we can't possibly honor that agreement because somebody else, say, Mass Real Estate Rentals, LLC gets deeded the property in 2016. They take over the lease, but if that provision's not valid anyway, you can't make them gift the property to you because they're not a party to the contract. So could that be fraud? Absolutely. But I think that you have a problem with the intent because fraud is all based on intent. And the city could have avoided this by doing what they needed to do. They drafted these documents. But
if I'm dealing with an unscrupulous lender and I at my home closing, I signed 1 million documents. Yeah. And what I'm signing is that I've read and understand and agree to, and not a single client
Nobody
understands
reads it all.
What they do. We don't bother reading it. Right. We're certainly not going to understand it if we read it. Would I have recourse if let's say a bank was unscrupulous or a lender? Would I have recourse, or would I be in the same boat that you think the city is in right now?
I think you'd probably be in the same boat because you put your signature on it, you own it. If you're saying you read it and you understand it, that's your signature. Is that your signature? Did you sign this? Yes. Did anybody force you to sign this? Nope. You signed this voluntarily? Yeah.
But I was deceived in signing it. I was told these are the conditions, and then I got to the fine print, and
I think that's a hard sell.
And that's why I have to have an attorney present at my signing.
You sign something, you own it. That's the way that the law looks at it. If you're signing saying that you've agreed to these and you've read it, and people do it all the time. In court agreements in housing court all the time, we have tenants sign that say they understand that they're signing the agreement and they, have the right to go before a judge. They don't have to sign the agreement. They're signing it freely, willingly, voluntarily. They think that it's fair and reasonable. And then they come back and go, well, I signed it, but I didn't actually know what it said. And, in housing court, we have housing specialists that go over the agreements with all the tenants who are unrepresented. So we see it all the time, and that argument always fails. You signed it. Do you speak English? Yes. Did you read it? Yes. Did you read the paragraph that says that you understand this? Yes. But you still signed your name to it. Yes. And you agreed it was fair and reasonable. Yes. Why is it not fair and reasonable now? Well, because I don't think it is now.
And,
you know,
and this is why, again, you hire your own attorney at a time of closing in real estate. All right. Attorney Krista Emerson, thank you. I've kept you for over an hour. Again, if there's an attorney out there that thinks she doesn't know what she's talking about and she's wrong and you found your own loophole that may, make her be wrong, I'd love to hear from you. Teddy Panos at InsideLowell.com. Reach out to one of your friends who knows how to get in touch with me. I'll gladly bring you in. Hell, I'd love to set. Would you be willing to sit down? If I can find such an attorney, would you be willing to have this discussion?
I'm always willing to hear the other side of the coin.
Okay. And that's why, listen, that's why we have judges and juries, right? Because attorneys argue all sorts of things and whatnot. But if your advice to the city would be don't pour any more good money after bad.
Right. And because then you run the risk of having to pay all that past due rent too. So on top of the legal fees, you run the risk of having to pay past due fair market rent.
Which he's now demanding. I'd have to go back and reread that lease, but hopefully that 15-year thing, if that's what they agree to do, doesn't call for any back rent. But anyway, all right. Thank you so much.
Thank you for having me.
Great to actually talk in person. Yes. Now that I know you're a real estate attorney, you're in trouble. You better block my number if you're smart. Thank you to Attorney Krista Emerson for joining us here. And again, if you need a real estate attorney, there you go. There's a free plug from InsideLowell.com. I don't know. I'm not an expert. She sounds like she knows what she's talking about, though. But hey, City of Lowell, if you Inside Lowell wants a court case, we want more. And I'd love to unearth some 2001 skeletons, believe me. And I still want to unearth some 1997 ones over a high school repair project that was supposed to be done. Tonight, school building committee meeting discussion, maybe we'll know how much extra it will cost us for the work that should have been done in 97 that wasn't. All right. Thanks for tuning into the Daily Pulse. Tomorrow we go live. Leslie Boder joins us. The fabulous Lindsay, 10 a.m. live here on InsideLowell.com or our YouTube channel. Don't miss it. Till then, everybody, please stay safe. Enjoy what's really a beautiful winter day out there today if you can get around the snowbanks. I'll see you on the other side.